He yanked a 4-year-old girl out of her bed with the intent to harm her, and you wanted to give her a cap of 2 years. Is that not correct?
Well, because I would like to explain, sir.
It is correct, and the court rejected it.
Sir, I know
This
the
was
case file.
I'm talking. It was a judge that was appointed by Senator Warner. This is not a right-wing judge. This is a liberal judge, and you know why he rejected it?
Sir,
he saw what you should have seen. A disgusting, perverted individual preying on children, that you dismissed the case. That is as shameful as anything I have seen. Quit defending the indefensible. You clearly don't.
Absolutely not.
You dismissed the case, and it's shameful.
Sir,
you're a coward. You are a coward.
Mr. Knott.
Thank you, Mr. Chairman. Ms. Minner, I'm so sorry. This is clearly a preventable crime, despite what has been said. As the father of 2 daughters, I can't imagine what you're going through, what you will go through, and candidly, I would not be acting as civilly with some of the people you're seated with had I suffered what you've had to endure. So thank you for being here. Mr. Descano, you said that, quote, we prosecute Virginia cases. Is that correct?
That is correct, yes.
And you painted a picture of being rigorous in your efforts to prosecute bad people, correct?
Yes, when we prosecute, of course, we take a look at every case.
Yep.
We are constrained by the evidence. We're constrained by the law. And I will tell you, Congressman, you know, I think what is happening here with the number of cases that we're talking about are that
I want to talk to you about one of those cases. I want to talk to you about one of those cases, sir. Mr. Hiram Rodriguez, remember that case?
I do.
Leading up to the crime that I want to talk about, the defendant's criminal history included multiple charges and arrests for indecent liberties, exposing himself to a child less than 15 years of age, disorderly conduct, illegally entering a property to damage, burglary. He was even sentenced, albeit I would say too lightly, while he was on probation, while he was under court supervision in June 15th, 2023 at 4 o'clock in the morning, Fairfax County PD responded to a burglary in process. A mother and her 4-year-old daughter were asleep in the same room but in separate beds. The mother was awoken when her 4-year-old daughter was screaming in the next room. She went to investigate. The attacker dropped the 4-year-old and fled the scene. It was clear that the 4-year-old had been abducted from her bed. Her buttocks had been grabbed. Her torso had been bruised. The victim displayed immediate bruising. The mother did not see the attacker's face, but the 4-year-old said he was a, quote, big man. Law enforcement identified Mr. Rodriguez by 2 ways. Forensics recovered a finger and palm print from the window that he jarred open in this case and matched footprints outside the house where he was standing with a mud print inside the house. Eyewitness testimony later identified Rodriguez as having been loitering for days outside this apartment building. He had been seen using drugs in the neighborhood, and he had been pacing around this particular unit in the days leading up to the crime. Police secured 2 warrants. One, statutory burglary, specifically alleging that Rodriguez entered an occupied dwelling, seizing a 4-year-old with the intent to commit murder, rape, robbery, or arson. Maximum penalty is 20 years. Abduction of a 4-year-old with the intent to defile such a person was the second charge, with a maximum penalty of life. Once it was handed over to your office, inexplicably so, you immediately reduced the burglary offense to a misdemeanor, which capped the sentence at 12 months. You then reduced the abduction charge to an offense that was a lower degree and capped the sentence at 10 years. When you entered into a plea agreement, you tried to bind the court so they could not sentence this person to any term over 2 years. Is that not correct?
Sir, I'm so glad you brought this case up.
Is that not correct?
Well, because I would like to explain, sir.
It is correct, and the court rejected it.
Sir, I know the case file.
I'm talking. It was a judge that was appointed by Senator Warner. This is not a right-wing judge. This is a liberal judge, and you know why he rejected it?
Sir,
he saw what you should have seen. He cited overwhelming evidence.
Can we talk about the evidence,
this person was a threat.
I know it and you don't.
Quit talking.
And I would love to tell you about it.
This person was a threat. He yanked a 4-year-old girl out of her bed with the intent to harm her, and you wanted to give her a cap of 2 years.
Sir, This
And
is a
then when the
great
plea
example-
agreement was rejected, what did you do?
Sir, this is a
What
great
did
example.
you do?
This is a great example of a case.
You know, I've prosecuted.
Where-
Now, I've prosecuted
And then
cases.
you understand
And when
cases
you're
that
evading
don't
like
have
that,
strong
you know what
evidence
that's a
then,
sign
sir.
of? Guilt. What did you do?
Sir,
You dismissed the case.
Sir, can I please
Mr.
talk to you
Miyares,
about this case
when you
if you want to
dismiss,
know about it so
be
much?
quiet. When you dismiss a case, what happens to that defendant?
He walks free.
Walks free. A disgusting, perverted individual preying on children that you dismissed the case. As the father of 2 young girls, one of them's 5. That is
I have
as
a daughter too,
shameful
sir.
as anything I have
Please
seen.
don't talk to me
Quit
that I
defending
don't
the
care about
indefensible.
people in my
you clearly
community.
don't.
Absolutely
You dismissed
not.
the case, and it's shameful.
Sir,
you're a coward. You
I'm
are a coward.
You won't even let me talk to you about the case.
It's
sir.
indefensible, sir.
Sure.
I yield back.
Thank you, Mr. Chairman, for holding this hearing on a really important issue that I think a lot of Americans care very deeply about. Mr. Descano, I want to start with you. I've got a couple questions for you. I've got a document titled Guidelines for Plea Bargaining, Charging Decisions, and Sentencing. And it states that prosecutors shall consider the collateral immigration consequences of the specific crimes the defendant is charged with and the detrimental impact the deportation removal has on the families and communities who those removed will leave behind. This is a document, this is your official policy. This is not from your campaign website. This is the official policy document as well. Is that correct? Do you recognize this?
Yes, you read a portion of the policy, sir.
That's right. I'm not going to read the full thing. 'Cause
Oh,
it's
I
quite
don't
long. It's about
expect you,
11
sir.
pages. It's about 11 pages, so I'm not going to read the full thing. I want to better understand how you weigh an illegal alien's immigration status whenever you're making charging decisions. Do you know who Ander Jose Cortez Mendez is? Are you familiar with that case?
Yes, sir.
Okay, this is a Guatemalan illegal alien who was arrested in March of 2024. He was initially charged with, quote, carnal knowledge of a 13 to 14-year-old. Just for those of us who aren't lawyers, can you describe just very briefly what does carnal knowledge of a 13 to 14-year-old mean in this context?
Well, sir, generally, a charge like that would typically refer to underage sex.
Okay, so he raped an underage person, an illegal alien who raped an underage American. Your office reduced those charges to a misdemeanor charge of consensual sex with a child 15 years and older. You offered him a 90-day suspended jail sentence. Is that correct?
Sir, based on the evidence that we had in the case,
So it is correct.
but it's not related to the policy, sir.
So that is correct. I just want to ask you, whenever you were making that charging decision to reduce the charge, how did you weigh the defendant's immigration status?
Well, sir, to be clear, I was not the lead prosecutor in that case.
It was your office.
Oh, absolutely, sir. I, of course, rely on my team of 50-some attorneys to do cases. But I think what is important is that oftentimes, as you know, sir, as a prosecutor, you know, we're constrained by the evidence, we're
I
constrained
just need
by
to know,
what we have.
how did you take into account the defendant's immigration status?
Well, sir, again,
in
I'm saying...
making that decision. How
you're-
did your
you're-
office make that determination?
Well, what I would say is that, and thank you for clarifying, if you take a look at the immigration consequences policy, or what
Let me ask it a different way. Did your office reduce charges against this illegal alien from a felony rape charge to a misdemeanor charge with a 90-day suspended jail sentence, in part because this was an illegal alien in question?
No, this was evidentiary based.
It was evident it had nothing to do with the defendant's immigration status.
So when
Is that your testimony?
If you read the policy, you'll see that
Did it have
explicitly
anything to
carves
do with
out-
the defendant's immigration status? It's just yes or no.
Well, sir, it was based on the evidence.
I'm asking you, was their immigration status part of the evidence?
I don't believe
Yes,
so,
yes
sir.
or no? You don't believe so? Your policy says that you shall consider their immigration
Actually,
status.
sir, if you actually read the whole policy, it explicitly carves out
Prosecutors
cases.
shall consider the collateral immigration consequences of the specific crimes the defendant is charged with and the detrimental impact that deportation removal has on the families.
It also mentions
line
that
for line.
it's not outcome determinative. It also
I
explicitly
understand, and
states.
I'm asking you if your office weighed the defendant's immigration status in making your charging decisions here.
Oh, again, sir, I was not the lead prosecutor in this case.
I'm asking
but
for your office. I understand you're not the lead prosecutor.
Exactly. I just want to be clear. But the way that the policy is written, that case should not have fallen under the rubric of this policy. This is a narrow policy and is meant to be a narrow policy.
An illegal alien, I think that would qualify, would it not?
Well, no, sir, because again, the way that the policy is being presented as it is outcome determinative.
There would
case.
be immigration consequences based on what charge you bring. That would clearly apply to this case.
No, sir. Again, that's the reason why I mentioned earlier. You read a portion, but not the entire 2 paragraphs of this subheading.
Prosecutors shall consider. I just want to know, just give me a yes or no answer. Did you take into account the defendant's immigration status?
Sir, again, I was not, but the way the policy,
did your office
the
take
way
it?
the
It's a yes
policy
or no
is written,
question.
no, they should not have taken.
They should not have.
That,
Okay.
that is not outcome determinative in a case like this, sir.
Great. Thank you. My time's up.
This explosive hearing turned into a brutal confrontation over crime, immigration, and prosecutorial decisions that left the entire room tense. The most emotional moment came when lawmakers discussed horrifying crimes involving vulnerable victims, including children. One senator angrily called out prosecutors for what he described as unbelievably lenient plea deals, questioning how someone accused of such disturbing acts could be offered minimal punishment. His outrage was clear. He argued that the justice system had failed innocent victims and accused officials of defending the indefensible. The hearing became deeply personal when one victim's family member was acknowledged. A senator, visibly emotional, expressed sympathy as a father himself, saying he couldn't imagine the pain the family was enduring. He made it clear that, in his view, this tragedy was preventable and should never have happened. Then the focus shifted sharply toward immigration enforcement. Lawmakers began pressing prosecutors about policies that allegedly considered immigration consequences when making charging decisions. Critics argued that illegal immigrants accused of serious crimes were receiving softer treatment because prosecutors didn't want convictions to trigger deportation. One intense exchange centered around a case involving an illegal immigrant accused of rape. A senator repeatedly asked a simple question: did immigration status influence the decision to reduce the charges? But instead of getting a direct yes or no, the prosecutor kept pointing to policy language, legal evidence, and procedural nuance. That only made lawmakers more frustrated. The prosecutor insisted decisions were based on evidence, not immigration status, but senators kept highlighting wording in official policy documents that explicitly mentioned considering collateral immigration consequences. That phrase became the center of the argument. Critics said this creates a dangerous double standard. Their concern was simple. If prosecutors worry about deportation consequences for defendants, does that mean American citizens and victims are being placed second? The prosecutor pushed back, saying the policy was narrow, misunderstood, and not outcome determinative. But lawmakers weren't convinced. The repeated inability or refusal to provide a clean answer only intensified suspicion. The overall tone of the hearing became one of accountability versus bureaucracy. Lawmakers argued that ordinary Americans don't care about legal technicalities when violent offenders are walking free or receiving reduced charges. Their message was direct: public safety should come first. Another major theme was frustration with what some senators see as ideological prosecution policies. Several exchanges suggested that some offices are more concerned with social justice frameworks than strict law enforcement. Critics framed this as dangerous, especially when dealing with violent crimes or repeat offenders. Meanwhile, prosecutors tried to defend their offices by emphasizing legal standards, evidentiary challenges, and judicial oversight. They argued that plea bargains and charge reductions aren't unusual and are often necessary depending on what can actually be proven in court. But emotionally, that argument struggled to land. Because when lawmakers repeatedly referenced children, victims, and violent allegations, legal explanations sounded cold and detached. That's what made this hearing so intense. It wasn't just about policy language. It was about trust. Can Americans trust prosecutors to prioritize victim safety over political considerations? Can immigration-related consequences ever be separated from justice decisions if written into official policy? And perhaps the most powerful takeaway, when prosecutors avoid giving direct answers, it fuels public anger instead of calming it. By the end, lawmakers clearly wanted to leave one message behind. If someone commits a violent crime, their immigration status, personal circumstances, or bureaucratic policy language should never outweigh accountability. The prosecutors defended themselves. The senators attacked. The victims' stories dominated the room. And what began as a policy hearing became a fiery national debate over justice, immigration, and whether the system is protecting the right people.